We have recently started awareness campaign on cyber fraud in association with Mumbai Police Cyber Crime Wing, and very soon we are going to have such program online for this audience also of various societies. Only date need to be finalized. In principle, agreement has already been done. Uh, we have adopted a lot of schools in Palghar. We have blood donation camp. Since July, we have done 10 blood donation camps here. We have one of the very important project we started, Swam Siddha, where we are supporting or empowering divorced women, making them self-reliant with the help of Family Court Bandra. We are starting IT Innovation Center, where IoT, 3D printing, robotics, data science are going to be taught to youth from 18 to 30 years of age, and they will be mapped to their jobs. Yoga classes are regularly running in association with Yoga Institution at Rotary Center. So a lot of such programs are there. And so I also welcome you guys to come and be a part of Rotary Drive, where we are serving the community, service above self. With this, I would like to hand over today's proceeding to Ramesh Prabhuji for the important topic, which is the redevelopment on private land. So, Ramesh, over to you.
Yeah, thank you, Dharmesh Sharma ji. Of course, redevelopment has become a talk of the town, and it has a lot of legal implications. Most importantly, when we go for a cooperative housing society's redevelopment in a private land, which is owned by the society, or it may be on the lease basis. So we encounter so many issues, especially the legal issues regarding the procedure adopted, transparency adopted, or various things. So we have with us Advocate Amit Mehta, who will be definitely dealing with the legal issues that need to be taken care by a cooperative housing society when they are going for redevelopment. And let me introduce Advocate Amit Mehta. So let me briefly introduce our speaker of the day, the first speaker. Thereafter, we'll definitely take up with the Sandeep Kangutkar, who will be dealing with the feasibility report and the role of the project management consultant. And at the end, of course, I will try to conclude with the various challenges that the housing societies are facing in the completion of the redevelopment. So with that, let me just introduce you to Advocate Amit Mehta, who has been recently awarded by Maharashtra Society Welfare Association, also as one of the leading advocates in Maharashtra. So with that, Advocate Amit Mehta is a practicing partner of leading law firm called Solex Lex, and especially they are experts in the redevelopment, housing society related matters, and of course MRTP and various court matters. Now, he was a BJP candidate for the MLC election held in the year 2018. He is recently appointed by the Maharashtra Cabinet Minister of Technical and Higher Education, Honorable Sri Chandrakant Dada Patil, and Sri Vikas Chandra Rastogi, the IAS officer, Principal Secretary to Academic Council of National Law University. This is a part of the governing council that overlooks administration and curriculum of 22 NLU, that is National Law University across India. In Mumbai, NLUC is, that is National Law University, is situated in Powai, Hirandani Gardens. Currently, Justice D.Y. Chandrachud, Chief Justice of Supreme Court of India, is the present councillor along with other judges as a member of Governing Council of National Law University in Center. So he is, as I said, is one of the leading advocates and regular faculties across board, whether it is a PIETA or MCHA, CREDAI, or any leading organizations. And I don't want to take much of your time, but I can only tell you that he will deal with the redevelopment, the challenges that the housing societies face in the process of redevelopment. Over to Amit, you can take 10 to 15 minutes, then we'll have few questions to be answered by you regarding the legal issues. Thank you very much.
So thank you, Ramesh ji. Thank you, Dharmendra ji. Incidentally, Dharmendra ji, I am also member of Rotary Club, Rotary West Coast. So I've been long time associated with Dr. Baal Inamdar and Neelam Inamdar.
Most welcome.
And of course, I've been associated with Ramesh Prabhuji also for quite some time. where we have been spearheading a lot of issues related to cooperative societies across Mumbai and Maharashtra as such. So thank you very much for giving this opportunity to me by the MSWA, Ramesh Prabhuji, Sunilji, and the entire Mahaseva News team. I'm sure that, redevelopment is the most burning issue today in Mumbai. If you see across Mumbai, the entire action of redevelopment has now shifted to suburbs. You can say from Bandra to Dahisar. That is the main place from where the action has started as far as redevelopment is concerned. And crores of rupees have been are being spent by the government also in rehabilitating people. There are different models of working on redevelopment. The biggest question and the challenge that lies with the members of the society is how to tackle redevelopment. And let me tell you that even though you keep the consultants, the good consultants across Mumbai for this, maybe as a consultant for all inspecting this procedure, but you yourself are your own advocate, you yourself are your own PMC, you yourself are your own quality engineer, and your involvement on day-to-day basis, time to time, will help you enable the completion of the project on time. You would also have known that since RERA has come into existence, Ramesh Prabhu did tell a part of the profile, but I would also like to tell the viewers that we are also part of the RERA drafting committee from 2014 onwards. When the new government, Modi government came, we are part of the RERA drafting committee, and in 2016 May it was successfully implemented across India and in different states with slightly different type of amendments in each state. Today, RERA has been successfully promoted and propagated by the government nationally. So we have one country and one real estate law. This is a big achievement for the government as such, because what had happened earlier, there was no single law which was binding on anyone. But now that there is one country, one law, it enables people and they are safeguarded. I'd also like to tell you that, the 79A procedure, which is very important, though it is not mandatory in nature and it is directive in nature. You would have seen the recent judgment also of the Honorable High Court. But it is very important to safeguard your own interest, especially members of the society where they are large in numbers. If you are few in numbers, maybe 10, 15 or 20, or if your plot size is smaller than 1,000 square meter or maybe 700 square meter, then it is okay. But if you are a large size society, then it is better that, you have proper regulatories in place and proper consultants in place. You'd also have known that, the government of Maharashtra had issued this circular in somewhere in 3rd of January 2009. And under this section of 79 procedure, the object was to bring clarity and transparency in the redevelopment process of the society building and also for the smooth functioning of the society. So since there were no prescribed guidelines earlier, when the redevelopment procedure started across Mumbai, but in 2009, the government did prescribe these guidelines. It is not a standard practice which was earlier adopted, but now due to this, there is a lot of transparency which has come, the confusion has come down, and of course, the litigation also has majorly come down. The directives there were under this procedure. Okay, the government had already notified through an IS officer, where he had basically put up a small survey and a small study within the societies and within Mumbai. And finally, it came into the existence in 2009. If members would know that, when your society is there and especially redevelopment takes place, the people who have never been dissenting also start dissenting. And this is because many times there have been managing committees who have been overpowering most of the members of the society, and they do not keep transparency in the entire procedure. The members normally are not taking into confidence in the process of development. There was always a lack of transparency. Appointment of contractors or developers was in a haphazard manner. There are lots of gross violations also which were happening in the rules and regulations and even the bylaws. There was no proper coordination between the architects and the project consultants who were executing the project. You would also know that now we also take out a feasibility report, and this feasibility report actually comes and gives some guidelines. Earlier, these reports were never prepared. So the government also stipulated some guidelines that a feasibility report be prepared. And based on this, the study group which was formed under the chairmanship of a joint register of cooperative societies of SIDCO, the circular was finally issued on 3rd of January 2009, and certain procedures were prescribed. Let me tell you in short the procedures which are normally prescribed under this guideline. One is to call SGM. Note that all SGMs have now to be video group photograph. If you don't video photograph, someone may try to hook you on a technical grounds. Though you may be keeping transparency, but still this issue may remain. Call the special general body meetings, receive written suggestions from the members for redevelopment of the building, submit the outline of the program for development, take decisions in the special general body meeting, and circulate the minutes of meeting to all the members. It was also with the purpose to issue a proper letter of appointment to an architect or a PMC, the legal advisor whom we are going to appoint for looking after the entire legal work and the paperwork, and all the guidelines of the architects and PMC, whether it is pre-construction or post-construction, is to be stipulated in an agreement or appointment letter, which we are normally issuing it to the PMC. Please note that the feasibility report, which is being made by the PMC, is merely a guideline, and you cannot hold them that you had earlier quoted this and now you are telling that the changes will be so and so. Please understand the rules and the laws change very fast, but the consultants need to be aware. You cannot appoint a consultant, or you should not appoint a consultant who has half knowledge. It is very dangerous. It may lead to crores of losses as far as your society is concerned. Coming to the procedure of redevelopment, you would know that once you appoint consultants, namely the legal advisor and the PMC or architect, you issue appointment letters to them, pay their advance fees, you book them, and then the procedure of tendering starts. Normally, any society would call for tenders of 5 or 10 developers. It is my humble submission that when you are calling for tenders, ensure that you also keep a sort of pre-qualification before issuing a tender. The reason I am telling that we have been seeing litigations across Mumbai where some developers enter into a society with a mere 20-30 lakhs of balance sheet and then give higher offers. The higher offers and lucrative offers are given only to lure you into more trouble, and members become greedy. And because of the greed, they ultimately end up giving the project to a developer who did not have any experience, and then he may be having a very small balance sheet. And because of this, he was not able to survive in the entire cash flow as far as the project implementation is concerned. Hence, selection of developer through the tendering process is very important, but pre-qualification of who will collect my tender also is equally important. The selection of developer, you would know that there are certain criteria we follow. If I have to tell you the top 5 criteria which we would follow as a legal advisor, and I'm sure the PMC also would vouch for that. One is he should have a proper balance sheet and profit and loss statement. Second, they should give a solvency certificate. Third, try to take the OC copy of the last 3 projects which they have completed. This would enable you to actually have a sort of certificate that the developer is not only completing the project on time, is also going and getting the OC also. You would know today half of the Mumbai has always been suffering because of lack of OC in many buildings. You would have seen in articles today that 50% of the societies either don't have conveyance or don't have OC. This is purely because the members have never been vigilant. The MOFA was largely there, but the execution part of the MOFA was not implementable due to lots of issues. Hence, when the criteria is finalized, ensure that this is one of the criteria which has been taken care of. Fourth important point when selection of developer, try to meet up the people of earlier societies and check out how was their experience with this particular developer. And fifth is more important, that ensure that all your documentation such as development agreement, power of attorney, if at all you're taking a security, then the security escrow letters or agreement copies or bank guarantees or any other security which you are keeping, the PAAA, that is called Permanent Alternate Accommodation Agreement. All these documentation are watertight. Please note, the entire case of a redevelopment would depend on only 2 documents. One is development agreement, which ought to be a registered development agreement, and a power of attorney. The power of attorney need to be not be said, but you understand it has to be given to a developer for him to execute this project. As far as development agreement is concerned, you would know that a development agreement would play a very important role. That's the only document on which the entire society survives. And you would have known a case in Supreme Court where the judge has given a judgment that if there is no registered development agreement between a developer and a society, the society is free to go ahead with another developer, unless and until a major amount has been taken by the society, either in terms of corpus or rent or some sort of EMD and security deposit. But these all payments are or can be returned, and you cannot be holded for not proceeding ahead with the development if your developer delays the project over a period of time. Now, as far as the selection of developer is concerned, you would know that sufficient quorum is required. Normally, 70-30 was the ratio which was required under the guidelines of 17A procedure. Then MHADA took out a circular and then it became 51-49. Now, most of the MHADA societies today are practicing under the guidelines of 51-49. So even though my 49% of the people are in oppose to me, I can still go ahead unless and until they have a striking reason why we should not go ahead with a particular developer. Please execute the minutes of meeting and pass the appropriate resolutions with appropriate wordings. Please note that the resolutions and the minutes of meeting should be properly vetted by your PMC as well as a legal advisor, because these documents would carry a lot of weightage in future, and it is very important for you to know that documents play a very important role. If you are right, but you have no documentation, you are wrong. But if you're wrong and you have some documents to prove that where you are today, you may still be heard by the court. You would have also seen a very classic case of Ganpati Niwas in Goregaon in Bangunagar area, where a minority was holding at ransom to the majority. And Justice Gautam Patel at that point of time had given a very classic judgment somewhere in 2016-17. The judgment I will put up in the group later on, and I'll request Ramesh Prabhuji and the team to forward it to the people at large. And a very good Times of India article also had come. Please don't get frightened by dissenting members. Dissenting members cannot stop your development. There are a couple of 2 or 3 classic judgments. However, there should be note of caution also that even though you have a classic case, and the classic case is that you are not a dissenting member and you are with the society, but if the guidelines are not followed, then you will always be hooked up by some dissenting member or the other. So please ensure that many of the documentation which you are doing are vetted through properly, even with the members of the society. Please give sufficient time to members of society. Please don't rush with the documentation, because this documentation, sometimes there could be some errors even by the consultant. And it is important for the consultants to understand that members may sometimes point out some important points, and that may be considered. Lastly, I would also like to tell that redevelopment procedure now has taken a very different shape in a city like Mumbai. Now you have one country, one tax law also. So GST implications are there. How, whenever you are getting a free area, then what words to be used, like displacement compensation and hardship compensation words we use, so that you're not taxed also, because these amounts which you're getting as corpus and rent are not taxable. So Ramesh Prabhuji, thank you very much. I wanted to be short so that I can listen to people, have their queries, and then we can answer them, because this is the right forum to at least answer them. Otherwise, it is always a one-way procedure where we just give a bhashan and then they are never getting their answers also.
Yeah, Amit, thank you very much. Now, I will be definitely asking you the question after the presentation by Sandeep Kangutkar.
Yes.
Especially regarding the stalled project, where the developers, more than 5,000 projects in Mumbai or MMR region are stalled, and for various reasons. I think many of the projects also you have led with up to the High Court and terminated the developer and facilitated the societies to appoint a new developer. So that is again a new process post RERA, how the effects will happen to the flat purchasers and the, of course, existing members, how their rights can be protected. All these questions will come up after the presentation by Sandeep Kangutkar, especially on 2 aspects. In order to start a redevelopment, Sandeep Kangutkar is a leading architect, and he is a second generation architect. His father was also an architect, and his firm is functioning for the last 30 years. Now, he has been the PMC and the architect for number of societies for the self redevelopment also, and also for selecting the developers and taking care of the societies in the process of redevelopment. He is the managing director of One Stop Project Management Consultants Private Limited, and as I said, he is a member of Council of Architecture, and he has a wide experience regarding the revival of the stalled project also, where around 3 stalled projects have been managed and taken over by him, and now the projects have come to the stand of implementing or rather obtaining the OC, and people have started occupying the premise also under the fit out position. So we have with us Sandeep Kangutkar. Sandeep Kangutkar, you need to highlight how we can start the process of redevelopment and what is the role of a project management consultant, whether it is advisable to appoint a project management consultant, who are the people involved in the project management consultant, and then last is feasibility report. Mr. Advocate Amit Mehta has rightly pointed out in the beginning only that to start the process, you have to have a feasibility report. What do you mean by this feasibility report? What are the various inputs that you need from the societies, and what is the output, and what the society, how the guidelines are given to the society by way of a feasibility report? So over to you, Sandeep Kangutkar ji.